Welcome everybody. I'm Elizabeth Beattie. I'm a partner at the firm and also the head of the in-house lawyer services. Thank you for joining us today for this session focusing on managing business needs and meeting regulatory obligations. We're going to have a look at the obligations for in-house lawyers and some practical ways to safeguard your independence. A bit of housekeeping before we get going. This is a Zoom webinar that's being recorded. It's intended to be interactive, so there'll be a short presentation from me and then over to you for your questions and comments. This is part of our ongoing series of added value sessions for our in-house lawyer contacts. It's designed to be relaxed and allow you to pick the brains of our experts. If you're not comfortable with asking questions on camera, you can ask via the type chat facility at the bottom of your screen, and we'll try and deal with that during the course of this hour. If we find we can't get through everything, what we'll do is we'll pick up your questions and respond to you directly. So if you're able to make sure we know who you are, if you use the chat facility, we'll then come back to you. We'll start with an introduction and then a presentation from me. I'm afraid you hear a lot from me today. I'm the dispute resolution partner, as I've said, but I'm also the compliance officer for legal practice at Harris & Clark Rickaby, so responsible for overseeing compliance for this firm and the solicitors within it of their regulatory obligations. Following my presentation, we'll then open up the panel to questions. I'm pleased to say that I'm joined today on the panel by my colleague, partner in our commercial team, Steve Thomas. Now, Steve's worked extensively in-house, so he has a very useful insight today. He's worked for various organisations, including Legal in General. So I think what we'll do now is start the presentation. So next slide, please. So what we're going to look at today is the standards and regulations, the STARs. It tries to make them sound a bit more appealing than perhaps they are. Now, it is an enormous amount of information potentially to work through to understand all the regulatory obligations. What I've tried to do is to pluck out what I think is perhaps the most relevant to in-house lawyers, to give you an overview. Clearly, we could spend hours, which no one has an appetite for, let's face it, talking about this. But I want to try and help you navigate your way around the STARs. It sounds rather fun, doesn't it? Now, the reason why I thought this session might be useful is because last year there was an SRA thematic review of in-house lawyers, which produced some interesting results. At the moment there are over 34,000 in-house lawyers in England and Wales, and what the results demonstrated is that perhaps some of the regulatory obligations are on the back burner in some businesses, by no means all. But it demonstrated the unique role that in-house lawyers have. You're employers, but you're also trusted legal advisors, and you're involved in driving the business forward as business partners. And that can create an automatic tension, really, because you don't want to be seen as an obstacle to the business doing something that it wants to do. But at the same time, notwithstanding that pressure and that desire to move the business forward, you have got some regulatory obligations which will, in certain instances, take precedence over your client's interests. So what I've mentioned there is, in this list, you've got the mandatory principles, which I'll talk about later. The code of conduct itself, again, we'll touch on the relevant points there. And we'll also have a quick look at character and suitability because of some cases that have come through. I don't propose to go through the glossary, I've just listed it there so that you know those resources are available to you. Right, if we could have the next slide, please. So, the principles, these are mandatory and underpin all that you do effectively in terms of your regulatory obligations. They work in conjunction with the code of conduct, which we'll look at next, but they effectively assume greater importance. Where there's any conflict between the code and the principles prevail. And I'm not going to talk you through each point of this because, but I think it's really important that I'm sure a number of you already are aware of it. But the key ones, absolutely fundamental: acting with honesty, acting with integrity. Solicitors are a trusted profession. The higher level is expected of us than others, which is right given the level of trust that's involved in what we do. Upholding public trust and confidence in the way that we do the work that we're authorised to do, and upholding the rule of law. Absolutely key to what we do. So in terms of where there's a tension between the two, you have to always remember that within what you're doing and decisions you make, that these will apply to you. They apply to firms, which isn't relevant to you, but they apply to individuals in the same way. If I could have the next slide, please. So I've mentioned the code of conduct. It's broken down into 8 sections as listed in the slide. Now, the key ones we're going to have a look at today is section 1, touch on maintaining trust and acting fairly. We'll have a look briefly at dispute resolution, not because I'm going to bore you with this dispute resolution and court proceedings, but because of effectively your duties to third parties, which may involve the courts, tribunals, and any inquiries. Key one, service and competence. A very important one, conflict, confidentiality, and disclosure at section 6. And then we'll have a quick look at cooperation and accountability at section 7. Now, the key thing here, when I talk about maintaining trust and acting fairly, it may seem that how is that relevant? But there are examples where in-house lawyers may be in a situation where they're asked effectively to deal with somebody, for example, who doesn't really know what they're doing, be it at another business. And there was a recent case, for example, where an in-house lawyer was dealing with a solicitor at a private client firm. Couldn't quite know why a private client law was dealing with effectively a commercial stroke corporate transaction, but they were, and that's an issue for their compliance team at that firm. But effectively what came out of it was the in-house lawyer, who's far more experienced in dealing with these commercial matters, realized that the private client lawyer on the other side had completely missed a point, which was really fundamental, crucial point to the deal. And the view was, well, what do I do? Do I just carry on? It's their lookout, it's their problem. Or do I have to flag this up? And the answer is that you have to flag it up because you have a duty to maintain trust and act fairly. And even if, especially knowing it's not somebody, it's their particular expertise, regardless of whether they should be dabbling or not, the SRA's view was you should have flagged that up. And clearly, if you're dealing with any individuals in any particular circumstances, your duty is there to flag something up and not try and brush something, pull the wool over their eyes or just think you made a quick win. If I could have the next slide, please. So before we sort of go through bits of the code itself, authorization is something important because there are instances where the SRA will take issue with people who aren't properly authorized. So Legal Services Act provides the statutory framework here that if you've got a current practicing certificate, you can carry on reserved legal activities except notarial services in the course of your employment. Now, what are reserved legal activities? They include conveyancing, litigation, court and inquiries work, regulatory work, and private client work. The Act, Section 15.4, limits that, but puts a limit on it so that you're not able to provide certain services which are not provided as part of your employer's business. And I mentioned code rule 10 of the Code of Conduct, because there are limits on what you may do outside of work, away from your employer or for contacts with your employer, that you can't conduct reserved legal activities unless you are authorized to do so, as I've mentioned, as a sole practitioner, an organization that's regulated, or a self-employed solicitor practicing in your own name. I only mention that because there have been cases where in-house lawyers have provided some advice to personal advice to friends and family which have covered reserved legal activities, and the SRA have taken issue with them. Also, it may be a situation where you're asked by a third party who may be linked to your business to provide certain types of work. You must be very mindful of the limits of your authorization as an in-house lawyer. If I could have the next slide, please. Briefly look at overseas rules. It may not affect many people who've joined us today, but for those that do have situations where they need to be spend time abroad, or they have offices and work multinationally, you will have to be subject to the principles. But the overseas ones are slightly, as you'd expect, less restrictive, because they'd have to take into account the rules and regulations of whichever jurisdiction you're working in. I've mentioned there, it talks about they don't apply if the services provided overseas are on a temporary basis. So what is a temporary basis? There's no hard and fast rule, but it's effectively where you need to be regulated. You have to get authorization from another regulator in another jurisdiction. Would then clearly the overseas rules would apply. In terms of timeframes, they say at least 6 months or more would account for work as a time limit period to kick in for when overseas rules would account. The situation clearly is though that when you are working overseas, the overseas rules apply, but the rules of the local jurisdiction, the one you're working in, will always prevail. It doesn't mean to say you don't still have to comply with your obligations to act fairly and act with integrity, and honestly, those continue. But if they conflict with the local jurisdiction rules, those local jurisdiction rules will apply. If I could have the next slide, please. So let's have a look a bit more detail of the duties of in-house lawyers. As I say, I could have spent hours going through this. So we can't do that in this hour today, but I think I'll pick up on some of the most useful ones for you. So you have wide obligations to report any actual misconduct that you're aware of, but also of issues or facts that you believe could amount to misconduct or should potentially be investigated because they may be in breach. So those are your wide reporting issues. You have that at all time, whatever happens, regardless of what the business may be asking you to do. You just have to be mindful of it. As I've already touched on, taking an unfair advantage of clients, I won't go back over that. But also not to mislead clients, not to mislead the court. I'll pick up again about third parties a bit later on, but you have a real issue here to mislead the court, be that by act or omission. So as I say, we'll pick that up in a moment. Code under the code, rule 3.1, act for the client on instructions received properly. Now that's really important one, and I know I'm talking to Steve beforehand, to have clear instructions in terms of what you're being asked to do, and who are you receiving your instructions from, and who should you be receiving them from, and who should you be talking about it when you receive instructions if it's not from the person in your normal reporting line. That's a key factor. Ensuring that the work that you do is competent and delivered in a timely manner. Now, competence is something we'll pick up again later because you have a duty of continuing competence, but it's important to ensure for in-house lawyers that you're competent, and where you supervise and manage others, that they're also competent. Could I have the next slide, please? As I've said, code rule 3.5, you're accountable for the work, for those of your own work and for those you supervise, absolutely key. And you ensure not just that their technical and business skills are up to date, but their understanding of the regulatory obligations are also up to date. Most important one, I think, we'll put a separate slide about it in a moment, is conflicts of interest. They're a real minefield. It's conflicts as well as confidentiality conflicts, and so we'll go through those in a bit more detail. But key to anything in terms of all that you do is that you're able to justify your decisions and actions, so that if the SRA do take issue, that you've got a clear record, first of all, for your own peace of mind, but that you can demonstrate to them that at that time a decision was made and the reasons for your decision. I'm very mindful in the role that I have. I get all manner of weird and wonderful questions come to me, and I'm conscious that, well, I've got to make a decision on this, and sometimes fairly quickly. And in what I do, I've got to ensure that it's always reasoned. It's very easy, and I think everyone would appreciate this. You're incredibly busy. One of the biggest challenges, the thematic review, highlighted by the SRA, and it comes as no surprise to anybody, is that the biggest challenge you have are your workloads and lack of time to deal with things. So when you're balancing all the interests of your client, their demands, and you're balancing at the back of it the regulatory obligations, it's not surprising that in quite often, sometimes the thought of the obligations and the requirement to properly consider those can be pushed on the back burner. I sort of go through navigating your way through this for you today, not trying to say that there should be a counsel of perfection, because that's simply not a realistic way to approach this. I know myself, business moves at a fast pace, and constantly evolving compliance rules and obligations, they evolve too. And marrying the two together is challenging. But really, truly, if you lose sight completely of regulatory obligations, there are sometimes very dire consequences. So what needs to be done is a way of working to try and embed the obligations into the culture and ensure that you are able to have ongoing training when required, and that there is some record of decisions made where, in situations where it's absolutely necessary, and a difficult decision has to be made, excuse me. I've put at the bottom of the slide, in reference to the principles, you know, you've constantly got to act with honesty, integrity, and act in the best interests of each client. And where the principles conflict, those which safeguard the public interest take precedence over your client's interest. And I know, talking to an in-house lawyer contact of mine, I think, well, they didn't necessarily they'd had training, of course, before on regulatory obligations, but it'd been a while. And so that they were saying, well, how did the public interest take precedence over my client's interest? And that's where the key things, the principles to act within honesty and integrity, really do bite. And so we'll have a look at those as we go through. Could I have the next slide, please? So a big issue that we'll have a look at is the conflict of interest. And the first question, I'd say, it may seem blindingly obvious, is who is your client? Now, if you're at certain organisations, it's your employer. But in other organisations, which may have a big, you know, may have multinational group structure, large organisation, you may have multiple clients, and that's where the risk of conflict can come in. And it's an issue that I deal with most days. I have a conflict query. Because where there is an actual one or a potential one, and having to think about the scenarios in which one may arise as to whether it's appropriate to act. Because the key thing is, can you act in the best interests of each client in relation to what you're instructed to do, or any aspect of it? And if the answer is no, then quite clearly, you know, you've got to understand why you can't, but you've got to be able to explain it more often than not to the business why you can't. And it's quite useful, I think, in those situations to try and assist, certainly if you've got a larger team with junior lawyers, that they understand the process to assess and analyse conflicts. Maybe sometimes a conflict checklist of sort. You know, no one size fits all with this. You've got to look at what your business structure is. But where instructions say come in, and you've got several group companies who may have competing or conflicting interests, you need to undertake an assessment, and it would assist probably the juniors to have an initial checklist, and at that point then they can go discuss it perhaps with the more senior line managers or general counsel to discuss it in more detail if they're not satisfied that it's okay to act, or if they have any queries at all. There is an exception I've mentioned here, which is of substantially common interest, but that is not to be used as a, you know, we've got a template, we just tick a box, and that there is a common interest, and that's fine, and we don't really need to assess it. If each potential conflict needs to be assessed in its own facts, and if there is an exception, you'd have to justify that, because if anything were to come out, which eventually the SRA looked at, you need a record to demonstrate that actually you thought about it, you've assessed it, and these are the reasons why it was okay. So, you know, where it comes to common interest, I often get people saying to me, well, the clients are okay with it, so that's fine. And you may experience that too. But that's not the test. That's part of the requirements of the client's consent, but that's at the bottom of the considerations effectively. You've got to ultimately assess the conflict and decide for yourself and be satisfied that actually it is appropriate to act. And only then, if you consider it's appropriate to act, you explain what the issues are to your clients, and the consequences if a conflict does arise, and you get their informed, you know, they give informed consent. That's absolutely key. The fact that, you know, when somebody wants you to do something, they don't care about your regulatory obligations. That's not the agenda for them, but you must be mindful of it, so that everybody understands exactly what your position is. And I think part of the thing that can help you in your role is if those key managers or the board or however your business is structured understand, without, you know, doing a session like this, that you have regulatory obligations, that you do, even though you're a trusted legal advisor, have to maintain your independence because of those obligations. So that when a conflict may come up, they actually understand what you're talking about and don't think you're being obstructive or an obstacle for them to get on and run the business. Touch briefly on own interest conflict.
Sorry, just cutting in there. I think in my experience, one of the real kind of difficult areas is where you have a dominant shareholders who are instructing you or getting involved in decisions, and you're sitting in between a sort of the interest of the business and the company and the interest of individual shareholders, and that I think that's a particularly tricky one to deal with, particularly if you've got a dominant or strong majority shareholder. And for me, I think the key part of that is just doing your prep up front and have it. If you are experiencing those issues where you feel like you're being unduly influenced by a shareholder in a particular direction, that's the sort of thing where I think you need to do your prep up front so that you do have a release valve, a process where you can take those sorts of questions and issues to somebody within the organisation who's independent. Ideally, if you've got a non-executive director, that type of person, but if you have a process in place that's documented up front, then managing those situations becomes easier. If you don't have the process, then it's a much more difficult thing to react to if that's happening and you're needing to make decisions in a sort of timely way.
Thanks, Steve. That's really useful. Thank you for that. Where am I on this slide? Right. So I was just going to pick up on the last point of this slide, which is avoiding own interest conflicts. I've advised previously people who've been asked to give advice to, say, clients of their employer. And that has sometimes created regulatory conflicts because of the connections with the employer. And I think it's quite useful to understand that can happen quite often because of so consider having a policy on who your team can advise and who they can't advise, so that everyone's absolutely clear to avoid the issue of an own interest conflict. Go to the next slide, please. Now, a confidentiality conflict, obviously, is a sort of separate aspect of the conflict of interest, but you have a duty of confidentiality to your client, and that's a continuing duty. And it's really important to understand where the conflict may arise, because, say, for example, you have assessed that you've got a common interest exception that could apply to acting for two group companies, just as an example. Everybody understands a conflict could arise and they're comfortable with that. So you've gone through the right process. During the course of those instructions, or whichever project you're working on, what comes out of it is there's some information. And that information then creates this tension, because you've got, at that point, then a conflict will arise because you may have confidential information in relation to one party, which means that you can't act in the best interest. You can't tell the other party, but it's relevant to them. But it means that you couldn't act in the best interests, or that would make it impossible for you to act in the best interests of the other party, because you know that the information that is confidential by party A, you can't disclose that, but it's to the detriment of party B. And so the confidentiality conflict arises because you've got knowledge of something which creates that tension. So my comment would be is that even if you've established who your client is, there is no conflict, or you've got a common interest exception, the ongoing duty that you have, that all solicitors have, is to monitor that conflict to ensure that at a later date, so as a result of a development, that the conflict hasn't arisen. And it's an ongoing duty right the way through. So once you've sort of gone through your checklist and satisfied yourself at the outset, you can't just put that issue to bed. You've got to keep track of it. There's also an issue of confidentiality conflicts where I've seen where, for example, an in-house solicitor worked in a niche industry. They moved to a different business within that same niche, and they had a duty of confidentiality as part of their employment contract, which no doubt I'm sure all of you did as well. They were then sitting on the other side of the table, effectively, in relation to a deal that they'd worked on at their former employer. So that because of the knowledge that they've got, they couldn't obviously breach their duty of confidentiality to their former employer, but because of the knowledge they got, it created a conflict. So be mindful of that when you're recruiting people, and if yourself you experience that you might find yourself in that situation, you can't just for fear of not saying anything, you must speak up and you must recognise that, because I've seen in situations like that people do take exception to it because of any sort of trade secrets or anything that might come out in the wash, and they do report those things to the SRA. So do be careful of that. I mean, there are exceptions to the duty of disclosure, which can be found in Rule 6.4 of the Code. You know, if the client gives informed consent to disclose confidential information, you know, sometimes you can't disclose information because it's prohibited for reasons of national security. So there are some exceptions, but, you know, reference to the code is really important with confidential information, just to make sure that you comply with the code on this. I've mentioned there some little tips at the bottom. I think it's really important, as I say, touching on the duty of confidentiality to be set out in the employment contract, and to have policies in place as well, to ensure that confidentiality conflicts are reported out and are monitored all the way through. I've also talked about a wider piece, and I won't go into it because I do like talking about legal professional privilege, which is another whole area of law, which we don't need to go into today. But clearly, if you're acting for two different clients, the common interest exception, you've got to preserve confidential information and preserve privilege. So it's sensible to have a sort of document preservation and confidentiality preservation policy in place to ensure that people are absolutely clear what they have to do and how it's to be done, and reporting lines if there are any issues with that. If I could have the next slide, please. So I mentioned earlier third-party obligations when I made reference to Rule 2 of the Code. So I've already explained where positions where you could be found to be taking unfair advantage of clients or others, even solicitors potentially. Undertakings, and I'm sure I don't teach anyone to suck eggs in this session, but you know, if you give an undertaking and you don't comply with it, that's because of the element of you know, acting with trust and integrity. If you don't comply with it, the SRA come down on you very firmly with that, because what runs alongside the principles is the enforcement strategy, which is very clear in terms of what the action that they will take when there's been a breach of the principles and the code, or both. It's very important that, you know, don't mislead clients, don't mislead the court or any others, be that by act or omission. Now that's important because you could say, well, if I would put a witness statement into court as part of proceedings that I was dealing with, which I knew wasn't true, and I signed a statement of truth, that was clearly misleading the court, which you know, I'm not sure anyone would do, but that you know, clearly will be actioned by the SRA. But what are the situation where it's not your witness statement, it's the witness statement perhaps of one of your board in relation to a particular matter that you have knowledge of? You're not signing the statement, you're not signing the statement of truth, but you file it at the court on behalf of the relevant party. Now, there's case law on this, where in fact, notwithstanding you personally haven't signed off a statement of truth, not your witness statement, you haven't lied, but what you've done is been effectively complicit in knowledge that it wasn't entirely true, being complicit by filing a statement at the court in those proceedings, knowing it not to be true, and that would be in itself a breach of the code. Looking then at Rule 2, you know, don't misuse or tamper with evidence. There is one in-house lawyer that I've spoken to, and there's reference to also in the SRA's thematic review about hiding data for the purposes of a disclosure exercise. Clearly, absolutely prohibited. Don't generate false evidence, persuade witnesses to change their evidence to suit the client's cause. And I think one that's quite interesting is not to make assertions or put forward statements that you know which submissions to court or others which aren't probably arguable, I should say, because I think there's a temptation sometimes, well, we'll just put a defence in and we'll just deny it, flat denial of it. Now, sometimes that might be acceptable, but in other situations, if you put forward any statements or any representations which are just effectively nonsense. And I see that all the time when I'm in court as well. That is a situation where if the judge is so minded, could take issue with that on the basis that that's a breach of the code. And you might think, well, that's a bit of that's not realistically going to happen. But I've actually seen that happen on 2 occasions, thankfully not with this firm, but and it's reported amongst the judiciary quite widely now, is that they want to stamp down on this sort of thing because there's too much rubbish effectively going through the court system at certain levels. So where they see it and they're satisfied that they can evidence that clearly is a breach of the code, they do report it to the SRA. If I could have the next slide, please. So let's have a look at your duties to the SRA. I've already talked about the wide-ranging responsibility to report matters, that actual ones or ones where you suspect there may be problems. But you also have a duty to cooperate with their inquiries and investigations. You know, I might get contacted with them with a simple query and they'll give you a tight time frame to respond. And unless you agree an extension, they will come after you. So, you know, and sometimes they might say, right, you know, for example, if you're certainly where they're financial institutions, they sometimes say, we're going to do a quick inspection, we're going to come and visit you. They do that with firms quite regularly, and you must cooperate, and it can be hugely disruptive to business. So that's why it's always useful, say, to keep good records of anything to do where you've had to make ethical decisions or where you've had to deal with conflicts, so that you've got a record of them, so that that information is readily available. So I've also talked about training there and ensuring that you make sure that the training is up to date. We'll talk in a moment about continuing competence, but there's, in the SRA's review, they said there were a number of junior in-house lawyers who said they've not had any regulatory training for over 12 months. And I'm not suggesting that's the situation for you, but I think it is somewhat neglected. I think, Steve, you'd say in your experience that was perhaps the case.
Yes. Yeah, I think there is, in my experience, it's a few years since I was in-house, but there is a sort of tendency for in-house teams to think that the SRA's rules don't apply to them, apply to private practice only. I think that is less so nowadays, but I think that, you know, I think there's a risk of that.
So clearly, training's absolutely, ongoing training's absolutely vital, because the principles and the codes, they get updated from time to time. The last major update was 2019, but you know, there are cases coming through the courts, there are cases coming through the Solicitors Disciplinary Tribunal, which might require some tweaks to your policies and a reconsideration of your practices to make sure that you don't run the risk of falling foul of the stars. The other issues to consider as well, duties to report if you've got any concerns about one of your colleagues' character and suitability, so effectively about any misconduct on their behalf. Clearly, if that's a junior solicitor has any concerns, they should be able to have a reporting line to deal with that. But you have a duty, and it's separate to each solicitor, to address that and report to the SRA, as well as anything that you're aware that's false or misleading, any criminal charges and any insolvency events. So those are ongoing duties that apply at all times, at all levels. Now, clearly, if you're in a larger team, you would want to be able to report that up to your line manager or the general counsel. If you are stuck, you can always call the SRA Professional Ethics Helpline, or many of you will have contacts with law firms. They might be able to assist you. But regardless of whatever the SRA Ethics Helpline will say to you, or another law firm, the responsibility and the duty is your own. So you've got to be satisfied that if you feel that, you know, that I would always say, if you think you should self-report something to the SRA, then after discussing it internally, then perhaps you should, because they're not going to take any issue with you telling them something. They go, thank you very much, thank you for reporting it, we're satisfied that what's happened, or that you've dealt with this issue, it's been resolved, you have processes in place to avoid this happening again, we're shutting our file on this. Over the years, I've had to self-report things where I thought perhaps were an issue, but what I do is say, we've ensured that this can't happen again, there's training being undertaken, we're monitoring it, and at which points the SRA say, thank you very much. They won't mind you doing that, But conversely, if you don't report something which you think should be and it later comes back to bite, they may take issue with you personally, even though you weren't the person who actually has any wrongdoing other than not reporting it to them. If I could have the next slide, please. I've mentioned already character and suitability. We're in a position of trust as solicitors, and so what we do inside of work is important, but also beyond work. There's a case of the SRA and Maine from memory where there was allegations of various things, including sexual assault, outside of the workplace, and that went all the way to the High Court where it was upheld. So your conduct, you have a duty to report all the matters that are listed on the slide, but also to behave in such a way that upholds the rule of law and upholds the principles. So, for example, you may want to consider what your social media policy is, because the SRA will now say, well, if you are publishing on your private social media platform, whichever one it is, X or TikTok, whatever, your, say, political views, if they were extreme, or if you created offence with anything that you published online, that would be something that potentially, depending on what it is, would be of interest to the SRA. Because if you're sort of effectively, if you've got somebody who's supporting terrorist viewpoints or platforms, that is something the SRA will want to take into account under character and suitability. So it doesn't stop at the office door, I'm afraid. It applies to your behaviours in and out of work. And if you have any concerns about colleagues and so on, those are issues that you may have to report as well in terms of character and suitability. Next slide, please. So continuing competence, other code name for learning and development. You're no doubt aware you've got to make an annual declaration that you have undertaken training on legal skills, business skills, management skills, and also regulatory obligations too is a requirement to ensure that you're up to date. And the training record should include what you've done. We often fill a questionnaire, what you've learned, what the course was, how it related to your role, when you undertook the activity, how it will improve your knowledge. And those sessions may be formal webinars or in-person conferences, but it could also include, training and mentoring, networking, and so on. I think it's really important, if you don't already do it, is that as part of the annual review, someone's annual appraisal, that they look at the regulatory policies, they update them and check that and update the checklist to ensure compliance, to safeguard the independence and minimise risks. You can see a typo on that slide, but just to make sure that they understand that it's an evolving piece and that it doesn't fall off the end of the table, regulatory obligations. I think that's the issue. And if your team's large enough to have somebody who's responsible for sort of organising or coordinating that continuing competence training, and incorporate into each lawyer's individual objectives, part of it some mandatory regulatory training. If I could have the next slide, please. Now you might laugh, why do I need a practicing certificate? But it's important to understand that if you're an in-house lawyer, if you're held out as a solicitor, implicitly or explicitly, so it doesn't mean you have to put solicitor at the end of your email. If you're doing the work of a solicitor, then it's effectively, but you're labelled and your job title is something different, then you are still required to have a practicing certificate. Only those with practicing certificates can deal with reserved activities, which can include conducting litigation, conveyancing, and so on. So it's really important that you assess who needs a practicing certificate, and most of you will, and that you do have one. I noticed in the legal press in the last week there was reference to some local authorities no longer willing to pay for practicing certificates for their in-house lawyers. That may create a bit of a minefield, but it's just important to remember it, because if you will be in breach of your obligations if you don't have a practicing certificate and you're undertaking some of these reserved legal activities. So, as I say, very basic point, but I think pertinent. I can have the next slide, please. So some checks, balances, and controls. So just a recap really. The key thing is that if you're making, embed ethical and regulatory obligations within your culture and what you're doing. And it's important that you maintain independence. I think one useful way to do that may be to have some training to the board members, to the CEO, to key people, so that they understand what your obligations are. They don't need a session like this, but just to know that you have separate obligations which can, if they conflict with what the business wants you to do and your clients want you to do, they can supersede the client's interests, as can the public interest supersede the client's interests and require you to make report matters. And if you don't do that, you run the risk of potentially, at worst case scenario, being struck off or fined, or both. And that necessarily can create a tension for you. So I think it's really a good idea to have in your employment contract, recognition that you have these separate regulatory obligations. It's only stating the obvious, you do have them. So to have that in your contract so that you don't feel that you're vulnerable if in this odd occasion that you have to say no to the business. I can't do this, we cannot do this. I don't think there's a situation where most businesses would be, having been advised that this is in breach of statute, contrary to sort of your obligations, would want to break the law and put you in that position. But you need to have that, they need to understand as trusted legal advisors, you still got that element of independence and that ethical and regulatory framework, which means that certain things you can't do. So I think it's really important to, as I say, to make sure you don't feel vulnerable, to have that, and also a governance protocol effectively. For example, the senior in-house lawyer, your GC, has a direct line to the CEO, for example, to bypass potential any other immediate line managers or other managers, to say, actually, this is a problem and I need to discuss it with you for these reasons, but not in fear that they're going to lose your job. So, as I say, checks and balances and controls. The key thing is to ensure that you are mindful of these obligations, that you can, I think checklists are really useful, not as a reason just to tick them and not think about the issues, but just to ask those questions, the key questions, to start to make a proper assessment. And of course, if you make a proper assessment, keep a record of it in case anything were to come of it at a later date. Can I have the next slide, please? So we've moved on to Steve. So I've talked actually a bit longer than I planned, but I think it's now what we'll do is we'll move on to our panel discussion. So as I say, we've got some questions that we've received already, which we can go through. And as I say, if you have any questions that you want to go through, do put them in the chat facility, or feel free to put your microphone on and ask us. So let me see what I've got here. Just bear with me one moment. So one question's come through. It's here. You've mentioned a checklist for substantially common interest exception. Do you have any suggestions for that? But I sort of guess I should have expected that question. But no one size fits all. But a starting point clearly for a checklist like that is, first, are the interests of party A and party B aligned? Question mark. Why is it necessary to use you as the sole advisor for each one? Not other than convenience doesn't come into it. So why is it necessary? Is it appropriate? And you've got to assess by reference to, as I say, code rule 6 of the code. Is it appropriate for you to act for both? Have the parties consented, and do you have a record of that? Have you explained the consequences if you've satisfied yourself that it is appropriate to act for both? That if a conflict does arise after we start acting, so checklist to remind you that you've got to, an email will suffice, but that they understand that you can act now perhaps, but that later for confidentiality reasons, as I've mentioned, you may not be able to. And have you also explained how confidential information will be shared and held? As I say, that's really important as well. I don't know, Steve, if you want to add anything to that in your sort of practical experience of a situation like that.
Don't have any immediate observation. That sounds rough.
As I say, there's no one size fits all, but there's the basics. But I would just say, it's very easy to create a checklist and tick boxes, and you tick the box and someone says, well, there's a record of it, and we were fine with it at the time, and if we get pulled up on it, at a later date, we'll deal with it then. I know it's sort of when you're busy, it's easier said than done, but it's really important for decisions like that you do a proper assessment and not just go through the motions. One question that's come in here is, what can I do to protect myself and my team from being forced by the board into a position where we're in breach of statutory breach of statute and therefore in breach of our regulatory obligations? It's an interesting one. I actually advised on something like this a while ago, because that's where the tension really does kick in. And it's really important, as I said, in that one, I said, look, I think, you have to explain to the board, you are trusted legal advisors, you've got your regulatory obligations, and those, I say, best practice for you would be to have that set out in your employment contract, that they acknowledge that you have got those separate obligations, which include reporting and so on. And you want to try and find a way through this. You want to work with them rather than saying, sorry, no, can't help you from our ivory tower, that's not the right thing to do and we can't get involved. You can try and see if there's an alternative way through without being in breach. And more often than not, there may be that the business, as I say, they don't want to be in breach of the law for the risk of the consequences, so they might change their plans slightly, or they might try a different workaround. But the key thing is that you've got some protections there, and I think it's really useful, as I say, to have in place or put in place some kind of protocol where this situation could arise, how it would be dealt with. Who do you report to? If it might be to the GC, and the GC has a separate protocol to go straight to, I don't know, the CEO or a non-exec director, as Steve mentioned earlier, in certain instances. It will depend on the nature of the business and the organisation, but you've got to have a situation where you can go and talk to someone about this without fear of having risk of being effectively then feeling vulnerable in your role. Okay, I'm just checking time. We've got 12 minutes of time for a few more questions.
I say the same observations as before, but that's classic, definitely. Where you could have 3 sets of duties to be thinking about. The business's regulatory duties, if it's regulated in some way, your SRA duties, and your duty to act in the best interest of your employer. At least in their commercial interest, and the answer to that is not easy. That's a difficult judgment to call, and in my experience, business people can be pretty unforgiving about being sensitive to your regulatory duties as a solicitor. They don't, there's a real risk they won't get that if they see that is taking you or making decisions in a direction which would actually be damaging, commercially damaging to the employer. So that is really difficult, which is why it's so important to have a process, so that you've got a clear documented way through that, which gives you a bit of time and space to consult with other people. And when we talked about the CEO and non-exec or a compliance officer, it's important. I think it's really important to have that process in place so that it gives you that opportunity to step away, because it's not, the answer to that will not be easy. It won't. It's not necessarily obvious. So you need some consideration time. So that's why I think the key thing for me is don't wait until you're in that situation. Spend the time now to have that documented process, to talk it through with the board so they're clear what your duties are, so it doesn't come as a surprise and you have a clear kind of route through.
That's really helpful. Thanks, Steve. Okay. Next question I've got here is I said this person, I won't mention names. I've been asked about data document where my employer and a third party have agreed to do so. There was no problem with the deal, just an admin error causing a delay in getting the documents signed and dated. It's not a position unique to an in-house lawyer, this one. I'm afraid this can crop up in private practice too. And there is no grey area about this. It's black and white. You cannot backdate a document. I'm sure you all know that. That's fraud. And I think people are a bit laid back about this, thinking, well, everything's gone through, and the money's that if the money's involved, it's all been dealt with in accordance with what we'd agreed, but we just haven't dated and signed documents. And the temptation's there, but you simply cannot backdate a document. You've got your duties to act with integrity, with honesty, and also, it's fraud. So the principles kick in, and so if you were tempted to do that, you really can't. And again, that's why it's important to have this understanding within the certain key people within the business of your regulatory obligations. Mistakes can happen, but that doesn't mean and that no one gets penalized for making a mistakes in this. But in terms of behaviors, when we all know you can't backdate a document. I don't know, Steve, have you ever experienced anything like that, where it's just an admin?
I've seen that quite a lot, and I think there's reasonably straightforward ways to just don't backdate it. You just date it the date, but it will probably mean some adjustment to the wording in the contract itself to make sure that it takes account of activities that have happened prior to the date of the contract. So I think there's reasonably straightforward ways of dealing with that.
I think it's just, again, workloads, time pressures. If something like that's missed, it's an admin error, and it just creates more administration just to remedy it. But you have to do it that way. You can't don't be tempted to cut corners, unfortunately. It just has to be some adjustments made. And I'm now regretting I've mentioned checklists, because I'm being asked about some more now. What about the checklist for conflicts and confidentiality? I think this is something, again, preparation for this sort of thing is really useful. What would I recommend? Well, first of all, who are the entities? What is the subject matter? And what are we being asked to do? Is it related? I mean, this is all straightforward stuff, but when you're busy, these questions just put in front of you can be quite helpful to extrapolate the information you need to make this assessment quickly. Would acting for both clients give rise to a conflict? And if there isn't one now, is there a significant risk of one arising in the future? Is there a common interest exception? Don't just, as I say, be tempted to just say, oh, I think there is, that'll do, we'll use that, we'll fill in that form and that'll be fine. Again, have clients agreed for information to be shared. And the key thing, is there any reason, is it appropriate for us to do this? Is there any reason we shouldn't advise on the matter? Or, as well, is there any personal connection? Because you never know what it is, any big team, whether there's any personal connection involved with the matter. And do you already hold material information, which means because of confidential knowledge, it would prevent you from acting in the best interest of the party, of one or other party. So that, I think, as I say, it's not an exhaustive list, but that is a good starting point for conflicts. And I think anything that helps you to get to the answer, if you can have processes in place and checklists in place, I think I know, Steve, you can tell me, I think that just saves you time when you're under pressure.
Yeah, the same thing. I think is do your work in advance, and then that makes those difficult situations. They won't be easy, but easier.
Okay. We've got 5 minutes left, so I've got quite a few questions here. I'm not sure I'm going to be able to get through all within the hour, and we will finish on time because I know that you're all very busy. Right. Question here is, I work within a fairly niche industry. I'm advising my current employer concerning a matter that for my former employer, and what I'm dealing with now is related, albeit fairly tenuously, to something I did in my previous role. How do I deal with my duty of confidentiality, and how do I work on this case, deal with this without potentially being in breach of my code of conduct and the principles? This isn't, and I touched on this actually during the slides. This isn't unusual because in-house lawyers do move around a lot, and certainly within a certain industry, this can happen where they have knowledge and find themselves on the other side of the table of their former employer. Now, clearly, most employment contracts will contain a duty of confidentiality, so you're bound by that. How long does that last for? There's no, unless it's prescribed, there's no set time limit, but clearly if you left 5 years ago, I think the confidential information that you probably had at that time is out of date. But if it is specifically related, that you've got knowledge relating to a deal that wasn't that long ago, that does relate to one you're dealing with now, you'd need to disclose that. And I think you'd need to sit down with your line manager and assess whether it's appropriate for you to be involved with that in part or at all. And depending on the extent of your knowledge and involvement and your assessment, it may be that you can't be involved in that particular aspect or that deal because of, first of all, your contractual duty of confidentiality to your former employer, but also because of your regulatory obligations in order to ensure that there's no confidentiality conflict going on, but also to act with integrity and honesty because you can not take an unfair advantage as well. Steve, is that situation ever experienced that for you or one of the teams you've worked with in-house?
No, I have no further observations really on that one. I think we covered it.
You haven't? No, I don't think there's much we can do. It's a case-by-case basis, but it's you say it doesn't. It's contractual and regulatory obligations will kick in there, but clearly a long passage of time, the information may be less relevant. Right. The question I've had here is, I've been asked to prepare a draft witness statement for a director in some court proceedings. After discussions, it's clear that his account of events conflict with my recollection of discussions in several meetings that we both attended. Steve's smiling at this because we'll find out why in a moment. I don't have to, I'm not providing a statement, but I know what the director's saying. I think he's saying is wrong, and I've told him so because I've got a note of that meeting. But he's refusing to amend his draft. What should I do? Now that is that calls into question, obviously, really pulls the code into question, the principles, and the code as well I've talked about it under Rule 2 for your duty to the courts. If you, as I say, and I touched on this again in the slides, even though you're not providing a statement, you would be assisting the supplier of a statement that you know, according to this, that you were in those meetings, that you know what they're saying is wrong. Now, it doesn't say here that the director knows what he's saying is wrong. It doesn't say that they've seen your notes. So I don't know what considerations have gone there. It might be worth sharing those notes with them just to cement their recollection, perhaps, and then perhaps they'll rethink their instructions. But if you do that, and I suggest you do if you haven't, but if you do that and they still say, no, I'm not changing it, I'm afraid if you were to file, if you go on and file that statement at the court, you are arguably in breach of your duties of the principles and code of conduct, because you're not acting with honesty and integrity, because you're complicit in a statement being served in proceedings in relation to your client, which are, to be untrue. So therefore you're misleading the court. Now there is a case on that, I think it's Brett and the SRA as well, which involved a solicitor who didn't provide a statement in his own name, but was by act of omission complicit in allowing a misleading statement to go into proceedings. And I'm afraid he came off the solicitor, came off the worst for that. So I'd suggest that in that one, if you have not disclosed those meeting notes that you attended where you know what he's saying is wrong, produce those to them and just say, perhaps you need to reconsider this. And if they then insist that you send it in, you're going to have to speak to whoever you put a GC or immediate line manager or whoever it is that you report up to about your regulatory obligations. Say, well, I can't have any part of this, because you can't risk that. Because as I say, the courts are treating this issue quite severely, as they should, because we're in a position of trust as solicitors. We've got to make, if you know you're not telling the truth and you're misleading the courts, then that is a very serious offence. So that's something that I'm afraid you may find that you're going to have to report up and that you cannot be part of. Right, I'm just conscious of time. I don't know if I say I had two other questions, but what I'm afraid I'm going to have to do is bring this to a close. What we'll do is any of the outstanding questions, we will contact you directly to provide the information, and we will also conclude this video and also the sort of answers that we provided during this session to the questions as part of our sort of follow-up, which will be in our newsletter and so on, so that you've got answers to these. If any other questions arise following this session, or you ever need any support, by all means do contact me or Steve. We'd be happy to help you. You've also can contact the SRA Professional Ethics Helpline. As I say, don't feel isolated with this. I sort of hope I haven't frightened people, but I think it's important to understand the frameworks that you can try and navigate your way as best you can around it when you're trying to sort of when you're working hard in your business day to day. But for the moment, thank you for joining us. I hope to see you at a future session and speak to you soon. Thank you. Bye for now.